and remember to do that. And that way, and it'll live forever on our website. I'll put the website information in the chat also. We are lucky today to have two people who I like to say were in the room when the Site Remediation Reform Act was first written. And, by the looks of these two guys, no, it was not in the 1800s. It was actually in 2008 and 9. At least Steve chuckled. George is logging off. Dr. George Berkowitz is my partner at Continuing Professional Education Services. He is a former assistant commissioner at DEP, a consultant for more years than he would like to count, and definitely an expert. He is a member of Site Remediation Licensing Board in New Jersey. Again, just a reminder that anything he may say here today should be his personal opinion and not the opinion of the board. Steve Sr., the co-chair of the environmental law practice at Riker, Danzig, and a couple other names. His name's not there, so I don't have to keep reading. And again, I will tell you that Steve's area of expertise has to be vast because he knows all, is involved in all. And there may be other attorneys. I'm not here to insult any other attorneys. He has an ability to explain it in a level that I think we all understand, and I think we all appreciate that aspect from Steve. So I'm going to stop talking, turn it over to them. Again, if you have questions, if you raise your hand, we'll definitely try to call on you. You have the ability to do that in the participant, you know what I meant to say.
Participant.
And we'll go from there. So I'm going to stop talking, considering I can't, and start drinking more coffee, and I'll turn it over to George.
Good morning, everybody. When we first conceived of this hour chat, we thought, this will be a hit and run type of thing. And then I started delving into my presentation, and there's a lot of material here. I think I don't believe you guys out in the audience have any sense of what either of these committees do and how they do it. And that wasn't the initial purpose. We're going to come up short on that. We just don't have enough time. I, for example, have 15 slides. That means a slide every two minutes, and each of those slides is very detailed. So we're not going to do that. We're going to whet your appetite, probably give you an overview of what the audit process is and what the professional conduct process is. And Steve will talk about how we apply various principles as well as various processes. Steve Senior is not only a good professional, he's a good friend of mine. Irrespective of sometimes which side of the table we're sitting on, he's always very dispassionate. He reminds me of myself. I've always been dispassionate as well, and even keeled, not. But at any rate, I do want to, before we start, I do want to recognize, is Janine on? Is Janine McGregor? Janine McGregor prevented me from using the flow chart on the audit committee. That's her claim to fame. But at any rate, Janine is the executive director of the board. We're so blessed to have somebody of Janine's commitment, intelligence, personal characteristics. Janine, thank you so much for what you do. I don't think Dana Hames is on. Dana Hames is another.
I think she is, George.
I'm sorry?
I think she is.
Dana's on? You know what? I got a feeling they're watching what I say, and so they can file a complaint.
I think they are too. I think they're here to watch you, not me, George.
And by the way, kudos to Dana. She does a wonderful job in writing up our memos. In fact, if I go back to college and get a real degree, I'm taking Dana with me so she can take some notes.
Thank you, George, for your kind words. Just to say, we just want to hear what people are thinking and asking about those two processes. We want to know what the issues are and what LSRPs, are saying about it, or what.
And yeah, and that's for public consumption. She's really monitoring my my performance, I'm sure, and I'll probably wind up with complaint. At any rate, and then Judy Morrow is a person who works for the audit committee, does a yeoman's job. So with all that, what I'm going to do is I'm going to try to talk very briefly about each of the two, the audit committee and the PCC. And the first question I always want to ask, and Phil, can they show raise of hands? How many people raise their hands?
Yes, they can.
Okay, I want you to raise your hand. No lying now. This is truth. There's no consequence. How many people have read the board regulations cover to cover? Raise your hand. What do we got, Phil? Phil?
I'm looking, I got 2. Why don't you keep going? I'll give you a tally.
All right, so, no, and I want to, okay, so I'm going to cut to the chase on this. Because if in fact you get audited, one of the things that you have to do is submit a audit questionnaire. And let me start from the beginning then, so people can have a chance to raise their hands. What happens in the audit committee? We have approximately 700 licensed LSRPs now. For the first time, the numbers have actually gone down a few, but into the 600s, high 600s. 10% of the audit population has to, I'm sorry, 10% of the LSRP population has to be audited every year. So that means about 7 people, we draw 7 people every month and proceed to audit them. The audit committee used to take a look at a comprehensive view of all the submissions of the auditee. You can't do that. It's just too cumbersome. So what we do is we select approximately 25 submissions that you as LSRPs have submitted and review them and take a look at how the department reviewed them, what they found, and that becomes a little bit of a basis, so to speak, for how we're going to proceed with the audit discussion. How many have been withdrawn? How many any timeframes missed, or things like that. So the selection process, we decided initially that the selection process, when I took over the audit committee, was going to be non-random and random. Non-random would be selected on the basis of some appearances of performance of individual LSRPs that looked like it could be improved. And we would meld those with random occurrences. We're way past that. Everything now is random. Everything, all the selection now is random. So if you're lucky enough, by the way, we have performed over 560 audits. So in the beginning, some of those were duplicates, but now you can't get audited, I believe, what, in 3 years after your initial audit or after an audit. And you can't get audited if, in fact, there's a complaint pending against you. So the audit committee essentially implements Chapter 5 of the board rule. And the Chapter 5 of the board rule says, what's the selection process? What's the audit review process? What's the outcome of the audit? And if in fact you've been cooperative in completing your audit. Yeah. Here's a very interesting short form that you have to fill out in 30 days after you receive initial notice of the fact that you're being audited. It's not terribly elaborate. How many times you've been arrested, how many times you've had withdrawals, how many times you've been dismissed, things like that. Did you, when you were dismissed, did you dismiss yourself? Did your client dismiss yourself? But on the back, there's a certification. Let me read what that certification says, in part. Basically, the first paragraph says, look, you understand that you're being audited, and this is page 404. You understand that you're being audited. You understand that we have the ability to talk to just about anybody we want, because you concur that we have the ability to do that. We can talk to past employers. We can talk to present employers. We can talk to DEP staff. We can talk to your mother-in-law. In fact, you are essentially saying you understand that you're being audited. You understand that the board is very interested in getting a comprehensive view in a relatively short period of time, I might add. We're pretty much caught up, but if I, in terms of the numbers of audits that were lagging before, but also I want to read to you paragraph 2. I certify that I have read the Site Remediation Reform Act and the regulations of New Jersey Site Remediation Professional Licensing Board, And I fully understand that by holding a license as an LSRP, I am bound by the requirements of the Site Remediation Reform Act. So if you raise your hand and you didn't read it, we're gonna fill out a complaint against you as soon as this is over. And also it goes on to say that you do allow the conduct of an intensive investigation as is required by the law. And then you realize that if in fact there is, you provide us with any inaccurate information, we have the right to take action against you, and which may include the suspension or revocation of license. So it's pretty powerful stuff. The whole certification issue is really plays into PCC as well. So let me go through this real quickly. The selection process, I said that 10% of the LSRPs are audited. Only the audit review team knows, this is important. This is very important. So in the audit committee, when we perform an audit, we used to appoint a licensed, an LSRP and a non-LSRP to do the audit. And it would be members of the board. Now what we do is the audit committee, which is comprised of Ira Whitman, Peter Strom, myself, and Dana and Janine at times, are not really part of the committee so much as our mentors. We do all the audits now. And why do we do that? Peter's the non-LSRP, Ira and I are both LSRPs. Why do we do that? For consistency's sake. We found that there could be a little bit of inconsistencies in how things were understood. And we wanted to make sure that there was a bedrock, if you will, of an understanding of how we review work that's being done by the LSRP. Now, the audit process is designed to go into your performance as an LSRP. So what will happen initially? The name is drawn. Somewhere I have, Phil, give me that wonderful next slide. Is it up, Phil? Nope, keep going. There you go. Now, most of you probably don't have this app. This is an app that takes something that's really easy to read, and it transmits it into handwriting. And I'm very fond of this app because it saves me a lot of time. And what I do is really an indication of how poor I am in dealing with computers. So the LSRP selected, the LSRP then gets notified that they're being audited. The LSRP then has to fill out the LSRP questionnaire, the audit questionnaire, in 30 days. That comes back to us. The LSRP records are then examined. We pull up 25 documents which have been submitted and take a look at DEP's comments as well as any other pertinent information relative to those documents. We then discuss it, and then the staff, Judy Morrow and Dana primarily, will take a look and say, this is what we found. And they do that in a preliminary memo. This is what we found, and this is what we think the issues are. And at that point in time, we can then determine whether the audit person needs further investigation or we can complete the audit. If in fact we need further investigation, and many times we will call the auditee and discuss with him, almost always when we always when we have questions, we'll call the auditee and ask for an explanation. Sometimes we'll follow up with another call after we have the first call. So we really try to dig down. Now, let's keep going, Phil, down or to the next one. So now the audit committee then considers the recommendations, and then the audit review team can interview anybody they want. They can interview the LSRP, they can interview NJDEP, they can interview past clients, they can interview present clients, they can interview employers, so forth and so on. So then if no issues are found, we complete the audit. If issues are found and further investigation is needed, we do not proceed. Let me repeat that. If we believe that further investigation is needed, we do not proceed. If we think that we've done all we should do in trying to come up with the issues, but there are some remaining questions, we will then file a complaint to the PCC. The PCC can either reject the complaint or accept the complaint or send it back, remand it back to us for more information. And when that's all, then when all that process is satisfied, the audit review team and the audit committee have completed their job. That's it. I will say that we take this very seriously, extremely seriously. I will tell you that the documents that I have here indicate how much work goes into these memos. They're very detailed. And I will also tell you that the audit committee, as well as the professional conduct committee, meet every 2 weeks. I just want to, if I can just pull up the agenda of, for example, of the audit committee, which is not on my slides, or I should say the complaint committee, and I'll do that while we're talking later. But it's very comprehensive, it's very complete, and it's a lot of work. The audit committee's meetings run about an hour. The PCC meetings run about an hour and a half these days. We have a very full agenda. Okay, next, Phil. Now, okay, this is the complaint form. I'm sorry, this is a license questionnaire. We can go to the next one, Phil. We're going to fly through these. I think I've said all I really need to say. This is a list of audit results. If you go to this on the board's website, you'll see that there are over 560. No, I'm fine. Sorry, 550 some audits that have been completed. Lot of work. Okay, now we're going to launch into the professional conduct committee. The professional conduct committee is responsible for receiving complaints and then determining what to do with the complaints that are received. The professional conduct committee is comprised of, hang on here, is comprised of Phil, who's the chairperson, Jeff Hoffman, who is a state geologist, Joanne Held, who's just a person in great standing in God's eyes. I said Phil and myself. Then Phil, I don't think I missed anybody.
You got it, sir. Just remember to talk into the computer.
Okay, sorry, Phil. And I'm looking away right now. So what happens at the professional conduct committee, any person, and a person, take a look at it, what your definition of person is. It's very broad, including DEP, including other organizations, including companies. Anybody can file a complaint. And in fact, you can file a complaint against people who you believe have not allowed you to do what the code of conduct allows you to do, and SARA dictates what you can do. And that means any person is potentially subject. This is interesting. Any person is potentially subject to an investigation, not just LSRPs. If any person interferes with the ability or of an LSRP to do their work, or gives misinformation, or in the process interferes with any aspect of SARA, they are potentially subject to a, and it relates to the investigation and the code of conduct. That person could be subject to the complaint. Next, Phil. Okay, this is on the website. This is on the website, and therefore I am not going to go line by line here. But the whole process is, and I want to make this very clear, don't forget now, the audit committee has now handed the ball off to the professional conduct committee in some cases. Some cases a complaint comes to, in many cases, and perhaps more of the times than not, complaints are received not going through the audit committee, but directly to the professional conduct committee. I want to be clear that the professional conduct committee does not make a final decision. Only the board will make a final decision concerning disciplinary actions. That includes dismissal, that includes finding no violation, as well as finding violations. And the Professional Conduct Committee, his job is to do a thorough investigation. The Professional Conduct Committee will form a complaint review team, which is comprised of one LSRP and one non-LSRP. They will do the investigation with the help of our staff, who does a great job. And then we will then take a look at a memo that the complaint review team and with staff puts together for the Professional Conduct Committee to consider. The Professional Conduct Committee will either say, hey, this is not enough. You want to file a complaint. There's not enough information here. Let's go back and do it again. Or they'll say, okay, this looks significant. And then the Professional Conduct Committee and the CRT will make a recommendation. The Professional Conduct Committee will then either accept the recommendation or reject the recommendation, right? And or just remand it back to the CRT and say, do it all over again. So there is an iterative process, and this takes time. Believe me, this takes time. I didn't mention up front how much time the initial steps involved in an audit now. The initial steps take about 3 months to complete. We're trying to get it down to 2, but it's a struggle. So in the Professional Conduct Committee, there is a process that we try to follow, and all this is done relative to discussion of any disciplinary action is done in closed session. In closed session, if the Professional Conduct Committee has accepted the validity of the recommendation of the complaint review team, they will then prepare a memo of their own. In closed session, somebody, Phil, or members of the complaint review team, Phil is the chairperson of the Professional Conduct Committee, will present the issue and complaint to the full board in closed session. This is the initial discussion regarding the complaint and what the complaint review team and the PCC, who's accepted the recommendation of the complaint review team or come up with their own, we'll talk about, we'll discuss, and people can ask questions. We do this in the first meeting. We believe that it's really, we know it's really important for the the board to be able to intelligently and completely discuss what is at stake in the issue. Now, we have a lot of latitude in terms of what we do as disciplinary action, including civil action. We can refer for civil action, which we have done. We can impose fines. We can monetary fines. We can impose other penalties of a non-monetary nature, such as additional training, which we've done as well, so forth and so on. So then what happens is nothing is discussed regarding that complaint. Again, I want to reiterate, at this point in time, only the complaint review team, not even the complete Professional Conduct Committee, knows the subject of the complaint. It's only after a final decision is made by the board in open session is the name of the individual revealed. In many cases, we go, holy gosh, what's going on here? But I want to make sure that you understand that if in fact there are individuals who may have known this person and have a subjective interpretation of what this person's abilities, that should not come into play. The only people who know the name are the complaint review team, and they have to sign a document that says they have no conflict and they can be objective in evaluating the performance of the individual LSRP. And that's a signature. And we also many times say, I can't do this. I know this person. Yeah, he worked for me. I can't do this. And then in that regard, we have another individual who knows the name of the person, and in addition to the complaint review team. So then what happens? Then go to the matrix, Phil. Okay, this is the matrix, and rotate it again, rotate it again. There you go. This is the the matrix that we have developed in determining what the nature of the complaint is and how severe it is. I want to tell you something. That something simply is that we did not have this guidance until I believe it was 2016. We did not even have, quite frankly, a detailed process until about the same time. And why is that okay? Because the Attorney General's office told us that Sarah was so specific that we were able to proceed without having any rule or guidance in place regarding these issues. And that came right from the Attorney General's office. So that's why we were able to take action during this period with which we really didn't have these documents. So I just really want to quickly I got 3 minutes left. And this is on the board, this is on the website. You can take a look at. But before we go there, there's one thing that I want to point out. When we go to the fines, and we're saying that the board is not constrained to find violations within these particular cells of the matrix. Now, there is some conflicting information that is here. Says, okay, we start with the midpoint and we work our way, but we don't go out of the individual cells. We have 3 factors, I should say, low, medium, and high for the violation, and then we have severity. And the LL is low for severity and for conduct. LM is low and medium, or medium and low for severity and conduct. Medium, high, low, high, medium, and HH, high, which means that if you have a 3x3 cell, you have 9 alternatives, if you remember your genetics or your statistics. Okay, I got 2 minutes. Next slide, Phil. We publish, we think that it's really important that complaints are learning tools. And therefore, whenever a complaint is finalized and there's a decision that there was a violation, the complaint is published. And if there's a violation, the name and license number is also published. And we think that this is a really important tool because, unfortunately, right now, we've been told that we should limit the amount of what we consider to be statements of interpretation, which I think we're wrestling with how we can expand that, because we believe that the first time the LSRP community should learn about what the board thinks of a specific action should be, the last time should be when a complaint is filed. We have issued statements of interpretation in the past. Next, Phil. Does that end?
That is all.
Okay, so I know I really went over this, and obviously I didn't do it incredible justice, but on the other hand, I want you simply to know that this is a process which we take very seriously. It's not willy-nilly, and I will tell you right now, our role is not just to be a cop. Our role is to also be protective of specious issues when it comes to charges against the LSRP. And when we first started this program, we had a lot of those. The board does not get involved in financial issues. The board does not get involved to a minimum degree of individual technical issues. That's DEP's purview. But initially, when we first started this process, we rejected a lot of complaints. As we all got smarter about the process, as we all became more experienced about the process, those rejections are getting fewer and fewer. And quite frankly, we have fewer and fewer complaints from the department as well. Only because the department now, I believe, realizes the schism between what they're supposed to do and what we're supposed to do, and what the LSRP's role in that process is. With that, I'm going to stop. I apologize. I hope that we've whetted your appetite. We can come back and do a 2.5, 3 hour course on this stuff because it's deserving of such. So I'm going to turn it over to my good friend, Steve Sr., who has had many opportunities to be in front of the board, not because we had a complaint against him, well, that could happen, So we are real privileged to have Steve here. He's an excellent attorney and he's an excellent human being. So it's all yours, Steve.
Well, thanks very much, George. George and I have known each other for a long time, well before there was a licensing board. And we've been doing presentations of one kind or another also for many, many years. And it's always a pleasure. So when George asked me to do this, I said, yes, of course. I wasn't sure exactly what it was going to be, because if you've seen George give a panel discussion, or you've been in a panel discussion with George, it can be free ranging. And, I frankly, I hope that this would be free ranging as well. I'll invite participants to ask questions if you have them. And George, I'll sort of welcome your comments. I did hold my tongue while you were speaking, but that's really because I was fascinated by the font on your presentation slides, much better than mine.
Your computer doesn't have that font?
It doesn't, but it looked good. So anyway, I will invite you to ask questions of things that are of interest to you. There is a lot of time we could spend talking about the audit process, the professional conduct committee process, the disciplinary process, the investigation process. I'm going to talk about some of those things. I'm going to talk about some decisions. George didn't necessarily tee up some of the issues or the areas where he and I might disagree, but maybe that'll come out a little bit. And I found this sort of title of this presentation, the last few words, what you need to know. Now, by the way, I didn't write this title, but question mark. I thought about that quite a bit, and we'll end with some comments about what you need to know if you're an LSRP and there's a complaint that's been filed against you, and hopefully that'll be interesting. Phil, next slide. This is a basic statement of the board's authority, things that the board does: administers the code of conduct, investigates complaints, imposes discipline, including suspension or revocation of licenses. And we have seen some of that. I've been involved in many cases before the board in one way or another. I've represented a lot of LSRPs who've been investigated by the board. I've been involved in some remediation cases where, aspects of the case got put in front of the board. George is right that the board, at least as far as it's stated in the Site Remediation Reform Act, has authority to take action with respect to violations by any person, not just LSRPs. And frankly, there are attorneys who've questioned kind of the scope of that authority. What kind of person could the board conceivably take an action against? They have taken actions against those who would hold themselves out as an LSRP who were not, those who might inadvertently have not been an LSRP when they were performing LSRP type activities. There hasn't really been, I think, a challenge or a scope to the authority over any person as far as the board goes. I think an interesting area here is retaliation, and maybe I'll wait for a next slide to talk about retaliation against an LSRP, which could come from anyone potentially, or even by an LSRP. Next slide, Phil. So these are the kind of categories, main categories of things, improper conduct that the board might take action against. I won't read them all. You may have seen this list before. By and large, what we see in terms of actions by the board is looking at violations of the professional code of conduct. And I'll say, well, I'll call them embedded violations of the Site Remediation Reform Act, the rules that implement the site remediation program. If you look at the decisions of the board, and they are illustrative, they're on the website, there are summaries at least, and they can be helpful to understand what the board is doing in terms of disciplinary actions and investigations. Most of them really are somehow you failed in the process administratively, as a process matter, you failed to follow guidance, you failed to use the right form or complete the form properly. And yes, there is, a form for the audit process. And so the bulk of the actions by the board address those first two. I mentioned retaliation against or by an LSRP. This is impermissible. If you're an LSRP, I don't know whether you've ever sat in a room where someone said to you, if you don't do X, I will file a complaint against you with the board. And there might be circumstances where something like that would amount to an impermissible retaliation against an LSRP. On the other hand, if as an LSRP, you're doing something that might be a violation of the Site Remediation Reform Act, and that complaint gets filed, the fact that the other party might have, I'll call it an improper motive, won't necessarily relieve you from investigation or discipline. So we haven't seen that too much raised by the board. Next slide. I think George already covered the penalty matrix, so I really won't talk to this slide. Next slide, Phil. George put up the flow chart for discipline, and I'm really focusing on the disciplinary process. The flow chart, I think, has it right, although it doesn't always go that way every single time. In the main, what happens is a complaint gets filed. The board gives the subject of the complaint an opportunity to respond to it. There may be a meeting between the LSRP and the complaint review team, or the complaint review team and the complainant. There is work that is not always, at least from the outside, transparent what's happening. The complaint review team is investigating. They're talking with the professional conduct committee. Recommendations are being made, and ultimately the board has to make the decision, whether it's a dismissal, finding of no violation, violation with or without an offer of settlement. And if you've paid attention to what the board is doing in terms of how they're making these decisions that violations have occurred, they're using kind of an interesting tool called this offer of settlement. Frankly, I think it's a little bit of a slippery tool in that the board states we have probable cause to determine that you violated the Site Remediation Reform Act. Here's what might happen to you if you don't accept our offer of settlement, and we'll offer to settle this complaint for a small amount, 80% on what we think is the finding. And I think by and large what's happening is LSRPs are accepting those offers of settlement, whether they have counsel or not. And I'll talk more about that later. Next slide. I'm going to talk about a few different kinds of disciplinary actions. There are a number of complaints that are on the board website. You may have seen them, where through the audit process, the board essentially determined that LSRPs had failed to notify the department when their clients were missing mandatory timeframes. And I think this is the type of violation that could be picked up by an audit. I think George mentioned that the penalties were really quite small, and some of them were duplicative, where again through the audit process the board had determined that the LSRP had failed to provide that notice that a mandatory timeframe would be missed. Next slide. This is another summary of a complaint where a significant penalty was assessed. I don't know whether this was picked up by an audit. I suspect it was an audit of one kind or another, where the board took a look at a body of work by an LSRP and with respect to about 15 RAOs, found many, I'll call them administrative violations, and assessed a rather significant penalty. Next slide. I included this one in LSRP. There was a penalty assessed, a small penalty. An LSRP determined that vertical delineation of groundwater was not necessary due to low concentrations and no receptors. There was a little bit of statement about that in some of the documents filed with the LSRP. Really the reason that I included this one is because even in my own practice and work with LSRPs, it's not infrequent that you come up against an issue and the question is this a variance? If someone, for example, the DEP or the board were to determine that a variance was required with respect to a matter that was addressed and that variance wasn't identified in the documents to the DEP, that is, that's a problem, and provides the potential for discipline. I think, sometimes it can be difficult to know, or maybe it's not difficult to know, but it might be within the professional judgment of an LSRP as to whether or not a variance is actually required. And where these investigations and complaints and then discipline get into more complicated cases where there's questions of judgment about whether or not the remediation complies with the tech regs, for example. In my view, it gets a little bit dicier in terms of what DEP or the board is doing. Are they, in a sense, substituting their professional judgment for the professional judgment of an LSRP? And I know that the board tries not to do that. They try not to, devolve into the technical issues, but rather to stay at a higher level, whether or not, the rules were applied, the guidance was applied, as opposed to, how in the details the technical judgment was made. With that said, I've sat in meetings of a complaint review team with my client LSRP, where the board member asked my client to draw a map of the site and demonstrate which way the groundwater was flowing, and other issues that really did go to the technical merits. I think one of the things that just demonstrates is that sometimes it's difficult to extricate professional judgment and technical issues from the more procedural aspects of ARCs and the tech regs and the rules that LSRPs and their clients are supposed to follow. Next slide. I included this one in part because George and I were talking about it this week, and it's it's a good result. I think it's a happy story. In summary, an LSRP attributed PCBs on the LSRP site to an off-site, let's call it a rail spur, and took the steps that were necessary to call that discharge into the hotline, to investigate it, to report it, and then issue an RAO. The DEP then followed up to require the rail company to look at whether or not the rail was a source, to investigate whether or not the rail was a source of a PCB discharge. The railroad company hired an LSRP, determined through a congener analysis that the PCBs were not from the rail, and filed a complaint against the LSRP. Well, when the LSRP was presented with the information that indicated that PCBs might have a source on the LSRP site, the LSRP properly addressed it under the rules. Next slide, Phil, if you don't mind. And amended the RAO, commenced further investigation, and in the words of the board, took the appropriate steps when new information was presented. And the board found that although the LSRP, my words, it came to an incorrect judgment or conclusion about the PCBs in their investigation being wrong isn't necessarily a violation of the tech regs or the code of conduct, and where the LSRP took the right steps to address it, even though the first conclusion was wrong, no violation was found. And this, this is really how it should work. So this is a good example of that. Next slide, Phil. We might have skipped one. I don't know. Maybe not. Thank you. Case 001-2015, there was a penalty assessed in this. In this case, an LSRP had completed a remedial investigation report, then dismissed from the site, and there was a new LSRP. I think between the client and the new LSRP, they determined that the prior LSRP really had missed the mark in terms of the RI report. The RI was, deficient in a significant number of ways. I think in some ways this goes to the concern that I have about, when is the board looking at the technical merits and professional judgment of the LSRP, rather than just determining whether or not the rules were properly applied. But I think this case had enough mistakes made, enough deficiencies, even of a procedural aspect, that the board came to the right decision here. I also included it because as an LSRP, you should realize that a complaint or the basis of a complaint can come from a lot of places. And I think the successor LSRP in this case, who came to the site, saw the RI that had been done, saw that it was deficient, probably was somewhat instrumental in both the complaint, the investigation, and the conclusion that some discipline was warranted here. So, a complaint might arise from a successor LSRP, a subsequent ISRA trigger, a review by the DEP, an audit by the board, on and on. It can come from many, many places. Next slide. A few lessons. George mentioned that early on in learning how to address these complaints, the board dismissed a lot of them, decided, this is not our purview. Fee disputes, contract disputes, really private party disputes. The board is really there to interpret and explain the code of conduct, not to get in the middle of disputes between private parties. And so we don't see as many of those complaints lately as we did early, and you won't be surprised that clients, remediating parties filed complaints against their LSRPs when they were concerned about fees. When they were concerned that there was an iterative scope of an investigation, the LSRP promised we would address this in the last iteration. So how many times have you heard that? More recently, the board is looking closely at timeliness, care, diligence. How are the requirements, the remediation requirements being applied in the cases? DEP is an active complainant, although George says maybe not as much now as it was in the past. I'm not sure whether that's true or not, but he'd be in a better position to know than I am. DEP has been an active complainant in the past. And, if you read these decisions, this last bullet is, one of the most important. The details in the documentation really matter. How did you document your judgment? Did you document the variance? How did you apply the guidance? If there are multiple lines of evidence that support your case, did you identify and distinguish those that don't? The details in the documentation really matter. Next slide. So what do you need to know if you receive a complaint? And I grant you this is pretty high level, because what you need to know probably depends on what the complaint is and what your case is. But one thing you should know is that you're obligated to respond. you may not necessarily be obligated to respond to every question in the way that the board wants you to do so, but the Site Remediation Reform Act does provide that LSRPs have an obligation to cooperate with investigations by the board. The response and the board gives you as an LSRP an opportunity to respond to the complaint. Really, they present the complaint to you and say, what's your response? And this really is an opportunity. It's an opportunity, obviously, to rebut the complaint that someone has made against you. It's an opportunity to present, information favorable to your case. That should be obvious, and to influence, to shape perhaps the investigation that the board will take of the complaint, or the view that they may have of it right from the get-go. The response is an opportunity to ask for things from the board. You might have questions, you might want information, you might want a meeting. And so the response is an opportunity to ask for things from the board. It's not completely a one-way street here. Obviously, if your case is complicated, and I've been involved in complicated cases, multiple sites or multiple LSRPs, or multiple sources of contamination, it's an opportunity to try to put those complicated cases in the simplest possible scenario or context, so they can be understood, and if you're the LSRP being investigated, to cast it in the most favorable way for you, and to hopefully influence the outcome. The third bullet, you should speak with and probably hire legal counsel at the outset. I recognize this sounds self-serving, but I commend it to you. I have talked with LSRPs who contacted me and then decided, not to retain counsel and to deal with the issue themselves. And I think sometimes that's, a reasonable thing to do. But certainly if you have a complicated case, you want to think about how are you responding? What are you putting in writing to the board? What potential pitfalls are there in the rules and the Site Remediation Reform Act and the Code of Conduct that might trip you up? And counsel certainly can help in that regard. I've never sent a bill for that first call or that first contact, so I really would commend you to talk to an attorney if a complaint is filed against you, and then make a decision about whether to retain and how to retain counsel.
Steve, quick question, Steve. In your representation of LSRP, have you ever seen that the LSRP had insurance coverage and you've been paid by an insurance company?
I have seen the possibility of insurance coverage, but I haven't had the need or the opportunity to sort of run that down for one of my clients. So as a business owner, you may know better than I whether you might have insurance for this kind of thing. I think it's quite possible that insurance coverage is available, but it really depends on your insurance. It also may depend on, if you're a company and more an employee, let's say, than a principal, how you address this issue with your company.
Okay, thanks. And you guys have about 5 minutes.
Yeah, sure thing. I think this is my last slide. And the last thing I'll just say about this is, this process can be very challenging professionally and personally. I can't tell you, I don't think there's an LSRP who I've represented who, didn't feel, didn't have difficult feelings about the fact that a complaint had been filed against him or her. Thought it reflected on their professionalism, and struggled with both, how to respond to the fact that their professionalism, their livelihood is potentially in question. How do they deal with their client, the remediating party client? How do they deal with their employer? How do they talk to their spouse about it? It can be a very challenging process, and not the least of which is the amount of time that it will take. And George mentioned this. I think the board has gotten better in completing these investigations and taking actions sooner, but I've had cases that strung on for years, and I still have a case that is, I have a case that's 5 years old, and it's not been brought to a resolution. And it's not the only one like that. I've had other cases that took 2-3 years, and so don't expect that this will be resolved quickly if a complaint is filed against you, because it's really quite a process.
Hey, Steve.
Yes, sir.
I want to take the moderator's right to interrupt. You and I could go back and forth for probably an hour on what was been said. I just want to point out a couple of things. First of all, DEP does not have the right to go after the LSRPs. Only the board does. That was not the original intent, by the way, of the first draft of the law. So the board is there to prevent undue specious issues attacking the LSRP, while we expect the LSRP to be a professional, and that's what this is all about. Secondly, the issue about missing timeframes, it's not that you just missed the time frame. It's that you have not communicated with your client what their obligations are and how the process is supposed to proceed. Missing timeframes is obviously partly the responsibility of the LSRP, but also the PRC, and they're subject to penalties. Much of the technical issues where we get involved are associated with not protecting public health, safety, and the environment. Your issue about the map being drawn, what people might want to know, the board might want to know, okay, which direction is the groundwater flowing in? Where are the receptors? Just to understand if your actions were protecting the public health, safety, and environment, because that's our primary concern. And so many of those issues do involve public health, safety, and environment, not that it was a particular violation of a particular portion of the tech regs. And then finally, there are details how you vary and in the tech regs. And if you don't, and using professional judgment comes with some baggage. You've got to document. If you don't do that, we're going to come after you. And I'm going to stop there, Steve, and give you the last word.
Did you just say you were going to give me the last word, George?
I did, but I didn't mean it.
Well, that's why it took me by surprise.
I almost passed out.
There you go. I know it's not true, but in any event, no, I don't want to run through the litany of things that you just mentioned or debate them with you. You got it half right. We can, if you want to stick around and do that later.
Well, you only got it a quarter right, so what's the other quarter?
Oh, okay. I don't know, Phil, I think we booked this until 9 o'clock, but I'm certainly, amenable to stay for a bit if people have questions. I don't know if there are any questions in the chat box. I'm really interested in what other people are thinking.
Yeah, there was only this question about inactive. The question came up is, has an inactive LSRP ever been audited? And I don't know the answer to that question. I know when you become inactive, really all that does is save you the annual fee, and you're not retained on any sites when you are inactive. But that doesn't necessarily, I don't know if your name comes out of the hopper. It's a good question. I'd have to look that up.
Yeah.
George, I don't know if you know the answer to that.
No, I suspect that you can audit somebody who's gone inactive and maybe even retired their license.
Well, if they retired their license, they're no longer an LSRP. So I would hope we don't audit them.
Yeah, but their RAOs are still subject.
You want me to answer this, Phil?
Go, Janine.
What's your question specifically? Can you hire someone who's on the?
No, no, no,
No,
Audit someone
no.
who's on the inactive list?
no. Has an inactive LSRP ever been audited?
How are you defining inactive?
You're on the inactive list.
Inactive list.
No, because they won't be on the NGEM's list they won't be selected randomly because they're not on the data miner list of LSRPs.
There's the answer. Okay,
Okay.
thank you. Yeah, because that goes the same. If you're in the middle of a complaint process, you're also not audited. So, but that's a different
Yes,
reason why.
if you have a complaint against you, you cannot be selected for audit.
Right.
Or if your audit has been completed within
2 years.
2 years.
2 years or 3 years. It's
2
there's
years.
Two.
2 years.
There's
Two.
there's, by the way, there's 2 different representations of the time frame that I found.
Show me the other and we'll fix it, but it's 2
Yep.
years.
And somebody asked the question, when I retire, no one's, well, there's a statement, when I retire, no one's going to find me. So, again, I mean, I think you guys covered a lot in a very short period of time. If people do have questions, either raise your hand or put it in the chat. I mean, Steve, I'm always interested, because George and I kind of sit on the inside. When an LSRP receives that notification of complaint against them, I'm quite certain there's a lot of different emotions and issues that go through their mind, but they have 30 days or 35 days to respond, request all those different things. How quickly does that really happen, and how does that process work when they call you, or what's the immediate reaction?
Well, I mean, I can answer that a lot of different ways. The immediate reaction is, I can't believe this is happening to me. Obviously, this is wrong, and how do I make it go away? Past that, it depends on what the complaint is. Most of the ones that I've been involved with are pretty complex, and facts have to be untangled, and potential violations anticipated. That initial notice doesn't say, we think you may have violated X. The complainant has to say that, but the complainant may not really know. And the board really isn't constrained by the complainant's specific complaint with respect to what the board will review.
That's correct.
So you can sort of inadvertently step in it, if you will, by identifying a different violation. My process obviously is to listen at the outset, to try to provide guidance, and here's where I think this might be going. But usually it's a very kind of collaborative process between me and the LSRP to figure out what's happening in the case, why is the complaint filed, what's the right response, what should we anticipate, and to make sure that's in some type of writing that goes back to the board. And that writing is usually a collaborative process. As for the time can be extended. I mean, it's not a statutory matter. And, I have found the board to be reasonable when we make requests for more time to respond in providing for that.
So a couple questions came in. I'll ask the shorter one first, which is an interesting question, and I'm interested to see how George responds. Can an LSRP get the internal board review notes and file from his or her audit?
The next question. I think that if it's in the public record, if we were minutes, for example, if there are minutes of the audit committee meetings, or even the PCC, I think that probably is operable. Other than that, I don't know. I don't believe, first of all, I don't believe the LSRP's records are operable, to be perfectly honest with you. Go ahead.
I was going to say, because Steve's got a little, almost smiled.
Yeah.
Yeah. Well, I can't, I'm trying to remember if I've made Oprah requests to the board for this kind of information. I'm pretty sure I never got anything like this, but it may have been quite a while. There are exemptions from things that can be provided or should be provided through Oprah, such as, personnel type records, but also something that's part of what's called the deliberative process. And I could see where some of this information, might in the first instance be withheld if it's part of a deliberative process. So I've never had occasion to ask for that. Be interesting to see what happens if you make an Oprah request. But I wouldn't be surprised if some of those records are withheld based upon some of these exceptions.
Another question, can you comment on the board's position on the liability of successor LSRP when assuming responsibility on site where previous LSRP's work that has significant technical and administrative shortcomings? Document. Does the successor LSRP have to report the previous LSRP issues?
It's in the code of conduct, and the answer is absolutely yes.
Well, what do you mean? What do you mean by that, George? Report what?
Well, the code of conduct says that in order to accept any information that a previous LSRP has performed, you have to correct all deficiencies and any deviations or problems you're supposed to correct. If you don't do that and you accept the work, you're potentially responsible for it.
I think that might be a little different than the question that's being asked. I mean, I agree with what you just said. And certainly if you're a successor LSRP, you come to a site and you see there are deficiencies, those need to be addressed. I mean, that's clear. Whether or not, if the question really is, do you have to drop a dime on the prior LSRP? I think the answer is probably no. But the deficiencies at the site need to be addressed.
And it's not difficult to connect the dots when that happens.
Sometimes the chips fall where they may. If deficiencies are identified, one way or another, that might come back to roost with the predecessor LSRP, right. As in the case that I put up on the screen.
I think so.
And the comment document. I think that's an exclamation point, not a question mark. Yes.
And I think sometimes it's more difficult that for an LSRP to assume a case from somebody. I would say it is more difficult when you are the successor LSRP than when you take a case from start to finish.
Yeah.
Because you are assuming the responsibility of work that was previously done. You're going through that. And in my understanding, it is the only time in the board rules where it says you have an obligation to visit the site.
Yeah.
So there's more on you when you're the successor LSRP.
And Phil, a lot of that comes to play where you're an LSRP and you're being brought in where DEP's already NFA'd certain portions of the AOCs. And then it becomes an issue, can you just accept, and this is particularly relative to ISRA cases, where you need to issue a whole site RAO at the end of the day. And if in fact you don't look into those NFAs, in my opinion, you're letting yourself be subject to some findings that you don't want to know about afterwards. And that's happened. Yeah, it has happened. It's happened a lot. DEP has NFA AOCs, and when when people have looked into them, they found that those AOCs that have been NFA'd are not really NFA'd. Shouldn't have been NFA'd.
I'm watching the chat here, and we're getting a few comments on these questions, and I love to chat and argue with Roger too. But in this case, I think he has it right. I mean, the code of conduct requires those deficiencies to be identified and corrected, but yet I still don't think it necessarily means, dropping a dime on the LSRP. I put that into the category of the chips will fall where they may, but the deficiencies do need to be corrected, and depending on what they are, may need to be identified in the document.
In general, I would say they do have to be identified both to your client and to DEP if in fact it impacts a milestone document.
Yeah.
I don't see any more questions or hands. So I would ask, we got, we're already 12 minutes over. If there was one takeaway from this morning, what would you want to leave with the people on the call?
Stay out of trouble.
Steve?
Be careful how you respond to a complaint.
Okay.
In all honesty, we have to understand, the LSRP community has to understand that we're in the throes of evolving a profession. And in the process of evolving the profession, there are certain requirements of the individual who are those professionals. That's what this is all about. It's also, the board is also there to protect the LSRPs from specious issues, as I said before, and we do a pretty good job on that.
There
Okay.
you go. George had the last word.
He said he would give you the last word.
He did. Okay, well then I'll take it.
Take it.
No, I usually agree with George about half the time. And, there's a lot of things that.
Wait a second, you want to defend that statement?
No, I don't. But this has been fun, and there's more to talk about. It's true, George and I were in the room at the beginning of this, and here we still are, even though it's a virtual room. This is not a perfect program. The board is not infallible, and obviously the DEP as well, nor none of us. But the program is a dramatic improvement in my mind over where we were. I like to say that it's easy for me to say because I'm not an LSRP, but it's not for the faint of heart. And especially on complicated sites with difficult decisions and pushing the edges of technology and what we know about site remediation. It's not an easy job, and I commend all of you who do it and do it well. And I'll leave it there.
Okay. Well, I appreciate George and Steve. Thank you very much for this presentation this morning. I think it hopefully clarified some issues. It opened up some areas where it made me think. I was taking notes. I need to go back and look at some stuff. Always learning every day. That's the one thing I do find. And I think at Continuing Professional Education Services, we're trying to help you understand all that. And for any of you who are out there who are UST certified, May 18th, we do have the refresher class for anybody who needs that for their license or their certification. Definitely something to do. And, again, I appreciate it. We will put this up on our website, cpesnj.com, for any of your colleagues to review. And, unfortunately, if a complaint comes your way, it may be worth going back to this seminar and fast forwarding to some of the recommendations and comments.
Phil, I just want to say one thing. First of all, the real value of this could have been the interaction between the audience and Steve and myself. Quite frankly, we didn't have enough time to do that. I would submit that next time we do this, it'd be a longer session with a lot of time for interaction, more time than we had today.
And I vote for in person.
Sounds good.
Everybody,
Steve, thank you, Steve.
stay safe, everybody. Be well, and we hope to see you soon.
Take care.
Thank you.